be seated. Veuillez vous asseoir. La Cour est maintenant en session. The court is now in session.
Thank you. Counsel for the appellant, please take the podium.
Just to clarify with the court regarding the time I have for my submissions.
Yes, all counsel will have 14 minutes each for their submissions. The court will be keeping the official timer. You are welcome to use your own timing device as well to aid you.
Justices, may I proceed?
Please do.
Good afternoon, Chief Justice and Honorable Justices of the Supreme Court of Osgoode Hall. My name is Adaora Olisa, and alongside my co-counsel, Kristina Cô-Đoàn, we rise on behalf of the appellant, the Attorney General of Canada. Before I begin, would the justices require a brief summary of the facts?
No, thank you, counsel. We've read the materials. Please proceed.
Thank you. Justices, this appeal asks a precise question: whether habeas corpus is available to inmates who cannot establish a legal entitlement to the less restrictive state they seek. Dumas answers this question clearly. It is not. Therefore, we ask this court to allow the appeal. We have 4 submissions for you today. I'll address the first, while my co-counsel will address the second. I'll first submit that the legal entitlement requirement in Dumas remains binding, and second, that on that requirement, the respondents do not succeed. My co-counsel will then submit that the dissent's framework, the majority's framework, undermines Parliament's statutory scheme for correctional decision-making, and that the federal court is the appropriate forum for reviewing administrative decisions. Turning to our first submission, habeas corpus has long been recognized for its application in the correctional context. The case of Dumas v. Leclerc Institute serves as the controlling authority on the scope of habeas corpus in the correctional context. In Dumas, it establishes the 3 categories of liberty deprivation that could give rise to a habeas corpus application. First, the initial deprivation. Second, a change in conditions amounting to a further deprivation of liberty. And third, a continuation of the deprivation of liberty.
What does a change of condition mean here?
Just a change in condition. For example, it would mean if there's a significant change in the states between the inmate's previous state and the next state. For example, moving from a medium security facility to a maximum.
Could it include a change administratively in terms of decisions?
Sorry, Justice, could you clarify your question?
So does the change have to be an actual change, such as a transfer, or can a change be something related to a decision about a transfer?
Yes, Justice, it could include a decision that does interfere with the inmate's deprivation of liberty. For example, that would be in the case of Mission Institute v. Kela, where a federal inmate, he challenged his transfer, and the SEC found that it was unlawful on the basis of lack of procedural fairness. So yes, in that category, the administrative decisions or administrative breaches in regards to the provisions can be found in the second category. And when it comes to the third category, on a proper reading of Dumas, it finds that the third category is only engaged where an inmate's legal state status has changed, where they've become entitled to a greater liberty and that entitlement is being withheld. As Justice Cote and Rowe stated at paragraph 96.
Before you do that, is that entitlement one related to an outcome, or is it an entitlement to a process?
The entitlement in regards to the second category,
Correct.
Justice? It would be related to the outcome. We submit that when it comes to the 3 stages, when it comes to the 3 stages of the habeas corpus framework, the legal entitlement is required at the first stage of determining a deprivation, as that is the source of where the unlawfulness comes from. And we submit that in Duma itself, when we're looking at the inmate there, he, despite being previously granted parole, he had his application denied because he did not yet achieve the status of parolee. So the deprivation crystallizes at the moment of legal status, not before. And this understanding is entirely consistent with jurisprudence both before and after Duma. So when it comes to the 1985 Miller trilogy, in R.V. Miller, Cardinal v. Director Kent Institution, and Morin v. SHU Review, they all established that habeas corpus in the carceral context is limited to challenging further deprivations of liberty.
Counsel, I understand that this is your colleague's purview, but I'm interested to know, just in a brief summary, how this framework undermines Parliament's scheme, as you said.
Just as it would undermine the Parliament scheme because when it comes to the habeas framework that our friends may suggest, if we were to expand it where legal entitlement is not required anymore, it would lead to a floodgate of applications that the courts across Canada may not be able to handle and truly give proper focus on applications that do amount to an unlawful deprivation. And we submit that the Parliament has assigned the federal court to review when it comes to administrative classification decisions, and that is a scheme that Parliament has set up in order to address concerns in that matter.
Counsel, can you please, I like nuts and bolts, I like basics. What is the grand purpose of habeas corpus?
Justice, we would submit the grand purpose is to protect people who are facing unlawful deprivations of their liberty. That is the purpose of habeas corpus.
Okay. And would you agree with me that courts have repeatedly said habeas corpus has never been a static, narrow, formalistic remedy or otherwise, correct?
Yes, we would agree.
Over and over you said to your friends might suggest, I'm aware that the respondents are going to suggest that there needs to be an evolution in the definition of liberty. Would you not agree that that fits right in with not keeping a static, narrow, formalistic definition, as we've seen with habeas corpus?
Justice, we would agree that habeas corpus is meant to be a flexible remedy. And yes, it has evolved from its role in previous centuries. However, as was mentioned in Peru v. Canada, its scope still must be tailored to its function, which is to address unlawful deprivations of liberty. The legal entitlement is important here because it gives rise to true levels of deprivations rather than cases where, and we would submit that at stage 2, the framework that our friends propose is not a true screening process, because by lowering the threshold at stage 1 to simply have to identify deprivation of liberty, courts would be required to hold a hearing. And this would lead to them having an influx of applications that they would have to hear, some of them, many of them that are not.
Counsel, I'm going to cut you off. I don't think you've actually answered the question that I asked. You agree with me that habeas corpus has never been static. It has evolved. So I've asked you, do you believe or do you disagree with what the respondents are going to suggest, that the idea of liberty, residual liberty, deprivation of liberty, that is a terminology in its definition that has evolved or should evolve as well?
Justice, we would submit that our framing of habeas corpus is in line with what courts have established when it comes to applications of habeas corpus. Yes, it is meant to be a flexible remedy, but legal entitlement is something that has been shown in cases before Dumas, such as in the case of Cardinal. Our friends may rely, as the majority did in the lower, that Cardinal is a case that does not involve legal entitlement, but we submit that is actually a misreading of Cardinal. Cardinal, the director, denied the inmates a fair hearing before confining them to segregation.
I'm so sorry, counsel, you're not answering my colleague's question about the evolution of the current state of the law. We're not talking about past application of the state of the law. We're the supreme over the Supreme Court, so we're allowed to overrule past law. Why should it not be overruled?
Justice, we submit that our framework, that habeas corpus, it's meant to evolve, but if we evolve it to a point where we are allowing a floodgate of applications come in that don't have, that involve cases that on many levels of deprivations, that courts, I mean, we must think about the role of the courts in this situation, how they would handle a surge of applications.
But it doesn't appear to me justified that in like a seemingly incremental change in the law as it stands necessitates essentially restricting inmates' ability to seek what the great writ, one of the most fundamental principles of all of our of law. So I mean, you know, the suggestion that we have to go by, you know, a decision from about 40 years ago, when this principle has been evolving, as my brother Justice said, perhaps earlier, since the 1600s, it strikes me as strange that, you know, we should be so scared just because Parliament and Attorney Generals have failed to respond to the needs of the system.
And building off of that, I imagine the introduction of the Charter also prompted these floodgate arguments, resisting this change to our constitutional structure. And now the Charter is a celebrated aspect of our state. How do you respond to that?
Justice, to both of your points, of course, the protecting the liberties, rights of prisoners and inmates is important. And we submit that within the Duma framework, that we should not get to a point where we are allowing applications for anticipated rights to certain security classifications. The legal entitlement framework allows it so cases that involve actual unlawful deprivations of liberty are addressed and do address the issues regarding liberty deprivations in regard to inmates. And we'll point this court to the case after Kala, where in that decision after that, the courts in Alberta struggled with the surge of applications and had to implement an accelerated procedure. But the issue is that we have no indication that that procedure actually worked to the best of its ability.
But it works. Strained, of course, but it works. So isn't that kind of the point? Is that courts, although we can be strained, we don't break. And we won't break. Like there's ways, in the civil setting, you know, you set case conferences, you have triage courts. What's preventing Parliament or preventing, you know, the courts themselves from setting up sort of like a process where you have a habeas application court, for example, right over there, and then you can deal with judicial reviews separate and apart, thereby, you know, getting over any jurisdictional humps. Why can't that be an option?
Justice, we would submit that, first to your point regarding that courts, in this case of Latham, it still worked. In that specific case, yes, they did implement a procedure, but there are courts in different provinces, they have different levels of judicial capacity. So that is a concern that the majority's framework does bring. And
so it's not a concern then across Canada, is what you're saying, because from 2006 to 2010 in Ontario, there was an increase in applications, habeas applications, but as the Attorney General of Canada said at the Supreme Court of Canada, some of them were successful on the merits, others were not, but there was nothing to suggest that the court was overwhelmed with unfounded claims. And so it does seem like this is a speculative concern.
Justice, we would submit that our concern is based on the practicalities of the judicial courts. And while yes, in the case of Ontario, that may have worked. Also, I see I'm lapsing my time. May have an indulgence to answer a question and conclude.
Yes, please answer the question. Thank you.
Thank you. The Ontario courts, Ontario courts do have a higher capacity compared to, because they have a larger population to deal with applications. But we have to think about what's the implication of the majorities framework has for the rest of Canada. And therefore, we would submit that even in this case, because the respondents, they did not meet that legal entitlement requirement, as they were not given, because their recommendations for transfer to minimum security were rejected, they have been lawfully placed within their medium security institution as they have always been. So to summarize, we will submit that the majority erred by departing from the legal entitlement requirement from Dumas, and by treating a static custodial status as a deprivation of liberty. Dumas remains binding, and the respondents have no legal entitlement to habeas corpus under the third category. So subject to any further questions, I will now pass it on to my co-counsel to address the policy implications. Thank you.
Thank you, counsel.
Good afternoon, Honorable Justices of the Supreme Court of Osgoode Cup. My name is Kristina Cô-Đoàn, and I rise before you on behalf of the appellant, the Attorney General of Canada. I will now submit the broader institutional consequences of the majority's decision. The dissent of the Supreme Court of Canada correctly observed habeas corpus is not and should not become an unrestricted remedy to challenge every aspect of correctional administration. I will make two submissions. First, the majority's decision undermines Parliament's statutory scheme for correctional decision-making. Second, the federal court, not provincial courts, is the appropriate forum for reviewing these administrative decisions. To my first submission, the majority's decision undermines Parliament's statutory regime, which governs correctional classification decisions under the Corrections and Conditional Release Act and its regulations. Within that framework, in Section 30, inmates receive written reasons for classification decisions. Those decisions are subject to periodic review, and inmates may pursue internal grievances followed by judicial review of the federal court.
Counsel, can we actually start? I'll ask you a question about your second part of your submission, which is that the federal court is the one suited for these, judicial review applications? I mean, it seems to me that that's a very obvious point, given that these are decision makers of the state making decisions, right? So the decision makers, and so their decisions are, of course, reviewable at federal court with judicial review. But if we, take out, or if we, go along with what your friends might submit today, which is that these go to Superior Court, I mean, there's not going to be a need for these matters to go to federal court. This is not a decision maker anymore; it's a judge who actually knows, the law, was really well, instructed on the law. Of course, they're a master of the law. So, what do you have to say to that? If we just go along with this, then we cut out the middleman, right?
The appellant would respond, Justice, that as Justice LaBelle observed in Kella at paragraph 76, classification decisions require intimate knowledge of the penitentiary's culture and the behavior of the individuals within it. And so, when it comes to wardens and correctional officials, they possess that expertise, and federal court judges reviewing those decisions will routinely engage with that specialized administrative context.
And counsel, why can't that evidence be put before Superior Court by way of evidence or affidavit?
For provincial superior courts, specifically exercising habeas corpus jurisdiction, they do not operate within the same institutional framework. More significantly, that means that this would fragment national oversight of the federal correctional system.
But counsel, the Superior Court does review this framework regularly and without issue in the context of involuntary transfers to a higher security level, which for many years have been subject to habeas corpus challenge. I don't think that has broken the system, that the Superior Court has had the ability to review that. They seem to have the expertise, and it doesn't seem to have fragmented the decision making. Can you speak to why you think, if you do, that things might be different in the context of a refusal to transfer than it is in the involuntary transfer context?
Yes, Justice. We do think that there would be a difference here. Specifically, the dissent notes within paragraph 186 that this creates a real risk that inconsistent legal standards will emerge across provincial jurisdictions with no mechanism to reconcile those differences short of appeal to the court.
Is
Why
it
is that
possible that those oh, sorry,
Yeah.
go ahead.
Why is that a problem? We're a huge country. The context in Northwest Territories is much different than the context in Ontario. And even within Ontario, there's a bunch of differences.
And in fact, the fact that if this does lead to a division in how the case law proceeds, that's what our courts have actually been celebrating for years, is the fact that provinces are entitled to interpret things slightly differently. Now, of course, when it comes to the unlawfulness of a habeas corpus application, you're probably going to get things that are a little bit more aligned, but that's just the additional context I've added to my sister justice's question.
Justices, this actually connects very well to my first submission that I will return to in a bit, specifically about how Parliament built the statutory scheme, which is the federal correctional policy, and it has to operate uniformly across the country. If classification...
Are you suggesting there isn't variation from institution to institution across Canada?
There can be variation, but when it comes to federal correctional policy, it is important to keep it uniform.
And so going back to the previous question, if there are different decisions emerging in different provinces, is it possible that that reflects the unique characteristics of the institution from which those decisions are emanating from?
Justice, to clarify your question, you are asking me about how if provincial superior courts choose to rule differently, this reflects an overall...
Why is that necessarily a bad thing if they are making fact-specific decisions that are focused on the specific institutions that are in their provinces?
Justice, we would turn to Vavilov, and specifically how, in that, the court recognized the importance of a coherent national administrative law in Canada. And our friend's approach would risk undermining that very coherence.
Mr. Counsel, that confuses me still. Depending on which province you are in, be it Superior Court, Supreme Court, King's Bench, they all uniformly apply the Controlled Drugs and Substances Act. They all uniformly apply the Criminal Code of Canada. Can they not uniformly apply federal legislation as it relates to corrections?
They can uniformly apply these types of things, but specifically our concern lies with, as a justice previously mentioned, the different types of legal standards that emerge within those provincial jurisdictions. That can then create a contrast to the uniform application that Parliament seeks with its statutory regime. And so now returning to...
I have a question about something else. You quoted the Supreme Court below, saying that habeas corpus should and cannot be an unrestricted remedy to challenge every aspect of administration in the prison context. Is that not a straw man? I'd imagine decisions about the menu, for example, in a prison, wouldn't be subject to habeas corpus applications. So not every aspect, clearly.
Yes, Justice, that is true that this wouldn't apply to every aspect, as we're talking about habeas corpus, which, using the test established in Kella, the applicant must establish a deprivation of liberty. And so when it comes to the quality of food within a prison, for example, or the type of music that the penitentiary's library has available, those wouldn't qualify under these.
Right, so contrary to the point that's already been made, I can't recall whether it's by yourself or your colleague, this isn't a floodgate for everything and anything to have an application. There's still a defined process. As one of my colleagues noted earlier, you would agree with me, there's in essence a triage process.
Yes, Justice, that was my co-counsel's point, and there is a limit within habeas corpus. However, we come before you specifically to ensure that it doesn't become this unrestricted remedy to challenge every aspect of correctional administration. And specifically, this is because there's already statutes placed within Section 30, for example.
Counsel, who's suggesting this becomes unrestricted? As I understand the argument that will be coming from your friends, there's still a three-part test to have to work through. This is the second or third time I've heard this context of unrestricted. I don't know where it's coming from.
For the context of unrestricted, the appellant submits that this specifically comes from the way our friend will apply, for instance, cardinal, and specifically how this applies within three stages of Dumas. And again, so going back to our submission on Parliament's structure, it is specifically to ensure that we have an ongoing institutional knowledge and correctional expertise throughout. And our friends will likely submit that habeas corpus must remain broadly available whenever liberty is at stake. The appellant does not dispute the fundamental importance of the writ. But the question before this court is not whether habeas corpus is vital. It unquestionably is. The question is whether it is the appropriate mechanism for reviewing discretionary administrative classification decisions that Parliament has already placed within a comprehensive statutory review framework. When a superior court grants habeas corpus ordering transfer to a lower security institution, it does not conduct the contextual administrative review Parliament envisioned. Instead, it renders a binary determination. The detention is then either lawful or unlawful. As the dissent warned, this risks distorting habeas corpus into an alternative venue to challenge decisions of collective correctional administrators. Our friends may suggest that this expansion merely ensures access to justice. However, the opposite is more likely. By creating a parallel remedy outside the statutory scheme, the majority invites routine classification disputes to be recast as habeas corpus claims, thereby bypassing the institutional safeguards Parliament deliberately established. As the dissent
Counsel, before you
notes,
proceed, didn't the court in May, paragraph 62 and 63, actually confirm that the internal grievance procedure that we have available under the CCRA for reclassifications is in fact not a complete, comprehensive, and expert statutory scheme? In other words, we do potentially have a gap here.
could you please repeat your question, Justice? I am afraid I did not get all of it.
We have a system that invariably has some gaps and some failures. Where those gaps and failures exist, why shouldn't habeas be used to fill it?
Yes, Justice. So the answer to this specific question is that there's a flawed grievance procedure and there's a need to fix it. However, that doesn't mean that we should replace it with habeas corpus. Again, Parliament retains authority to reform the scheme here, as the majority itself acknowledged at paragraph 75 of the judgment, citing May at paragraphs 40 and 44. And so the inadequacy...
I appreciate you're going into your last minute, but you are here for Canada. Fix it.
Justice...
The case we're talking about is from 7 years ago. You keep talking about legislative changes and gaps. We're 7 years later. Should the court not then look at that lack of forward progression and take action itself?
Respectfully, Justice, it is not our role to fix the statutory scheme in place. Rather, that power is vested in Parliament as part of a balanced governmental approach. And the inadequacy of the grievance procedure is a reason to specifically reform it, but not a reason to extend the writ beyond its proper constitutional function. I see that my time is elapsing. May I have a 30-second indulgence to conclude?
Yes.
Thank you, Justice. Honorable Justices, the majority's decision in Dorsey is well-intentioned but institutionally problematic. It bypasses Parliament's statutory review scheme. It fragments jurisdiction across provincial courts. The writ of habeas corpus is most powerful when it is reserved for clear and acute deprivations of liberty. We respectfully ask this court to restore the principled limits articulated in Dumas and to allow the appeal. Subject to any questions, that concludes our submission on behalf of the appellant.
Thank you, counsel.
Justices, may I proceed?
Please.
Thank you and good afternoon, honorable justices of the Supreme Court of Osgoode Cup. My name is Neha Gupta, and I, alongside my co-counsel, Ms. Anasofia Florez, rise on behalf of the respondents, Mr. Frank Dorsey and Mr. Ghassan Salah. In response to the legal issue before this court, the respondent has 3 submissions. Our first is that reliance on Dumas ought not to be given weight. Dumas has been attenuated for 1, legal change, and 2, social change.
What do you mean by attenuated?
We mean, Justice, if this court wants to continue to follow the entitlement standard in Dumas, we say that that entitlement standard has already been done away with. And what this court...
So you're suggesting that it's been overturned?
Not necessarily overturned. We simply say Dumas had a lack of clarity, specifically in regards to what unlawfulness meant. And our friends advance the position that unlawfulness means entitlement, specifically legal entitlement. And we say there's still unclarity there.
Counsel, do you say that Dumas is good law and that we should uphold it as good law?
Certainly, Justice, is particularly with respect to, for example, the 3 categories of a deprivation of liberty in a carceral context. We don't dispute Dumas as precedent. We say Dumas has been expanded upon. What Dumas meant has been clarified. And to turn to that issue, what we have to consider, again, is what Dumas meant by unlawfulness.
Well, counsel, on the topic of what does something mean, you've already used this terminology a couple times now, deprivation of liberty. Put that into layman terms for us, please.
Absolutely, Justice. A deprivation of liberty under the respondents' contention includes a charter cognizable liberty interest being denied.
Charter cognizable? Layman's terms, please.
Certainly. Where Canadians have a right to be free from unjustified state intrusion, they have the right to exist in a general population, they have the right to have their rights respected and affirmed even within prison walls. That liberty needs to be affirmed. Prison systems cannot simply come in and say there's no rule of law within prison walls. That was a judgment or a principle firmly rejected in Martino, so back in 1980.
You're not suggesting that the comprehensive and complete regulatory scheme that helps govern our institutional systems is the absence of any law, are you?
No, Justice.
We do have law here. And the question is, what is so significant in the failings of this existing system that it requires habeas to be understood in the way that you're proposing?
We say it's because of the underlying principle of habeas, and our friends put it best. The issue at stake before this court is protecting people from facing unlawful deprivations of liberty. And where our friends advance a standard of entitlement, we say not only does this fudge the requirements...
That's relative liberty, right?
Yes, Justice, residual liberty.
Residual liberty.
Certainly, but nonetheless, the position our friends take is that entitlement is required. We say entitlement, through basis of legal entitlement, is the result of a habeas corpus application. It cannot be the threshold requirement for an applicant to be able to access this remedy. We say this would be cyclical. And that is the basis upon which we say our friends' view that Dumas meant entitlement when it referred to unlawfulness has been reviewed before.
Well, this can this still be understood in light of the context of with the entitlement lens applied? Because really, at the end of the day, to me, Section 28 of the CCRA is what creates the entitlement. The entitlement is for the service to take all reasonable steps to ensure that the penitentiary in which a person is confined provides them with the least restrictive environment that the person is entitled to. That is the entitlement. So the entitlement, we don't need to do away with it, even if you say that we have already done away with it. Like, we can still fit this within an entitlement lens. So I'm kind of curious to see, how would you build on that? How would you fit this case into that entitlement lens if I'm of the opinion that there is an entitlement necessary?
We would say that for a claimant to be able to establish entitlement, though there may be a semantic confusion as to what entitlement means in our position, entitlement would mean an applicant demonstrating, with a basis in fact and law, that the current condition they are in with regards to the level of security of the penitentiary they are in is unreasonable, or that the penitentiary didn't have jurisdiction to issue that judgment, or that there was a breach of procedural fairness.
Is that what
Counsel, Chief Justice.
Is that what you're saying is necessary to pass the first stage of habeas corpus? Like to meet the threshold issue? And if so, let me add on that. If so, are you not collapsing the entirety of the test down into the first stage? If you have to establish or confirm or even inquire about whether the person should be somewhere other than they are, isn't that what the entirety of the test is supposed to figure out, and isn't that collapsing it all down into the first stage?
I'll proceed to answer your question on the premise that when you refer to the first stage, you mean a demonstration of a deprivation, not
Yes.
of unlawfulness.
Yes.
Okay. So we say that if we turn to Dumas is instructive here. So there is a question again of clarity on with regards to why Mr. Dumas' habeas corpus application failed. And there could be two reasons. Either Mr. Dumas did not establish a deprivation of liberty, or that he didn't establish that that deprivation was unlawful. We say Mr. Dumas' claim failed because of that second stage, not the first. And we do this because in the Supreme Court's jurisprudence, what was required of applicants or inmates when they sought to demonstrate a continued deprivation of liberty, so that first step, the only thing they needed to do, for example, in Chinna, was demonstrate that Mr. Chinna was still in a maximum security facility. So by virtue of that precedent, we say Mr. Dumas' claim could only have failed under that second stage, which is to say it must have been that Mr. Dumas could not establish unlawfulness. And what we say unlawful...
Wasn't it because he wasn't a parolee? Wasn't that a significant component as well of the decision?
Precisely, Justice. And our friends would have it that it is only on the basis of a lack of legal entitlement, but that would be putting the burden, we say, higher than our standard. So certainly, if an applicant doesn't have legal entitlement, neither do they have a legitimate claim. That's closer, that latter claim, that's closer to our standard. So if Mr. Dumas wasn't able to establish entitlement, he also, very likely so, wouldn't be able to establish a legitimate ground. We advance the legitimate ground standard because we turn to May and Kella. And specifically, the terms that are used when describing an applicant's burden in these two cases are, quote, raising a legitimate ground, providing some basis, casting doubt, or proper grounds. So we say that is actually what Dumas meant when it referred to entitlement.
But surely that can be surmounted in the pleadings if you just plead reasonableness or lack thereof, or, procedural unfairness, and you put that in issue. So, I mean, that second step of the analysis of the habeas corpus analytical framework, to me, suggests that, like my brother Justice said, we're really just collapsing everything into the first part of the framework, because it's so easily gotten over.
So To clarify, Justice, your concern is that by abiding by May and Kella and their delineation of what unlawfulness means, we would be somehow reducing access to liberty under the other two categories of Kella?
I think my fear, and because it's indirectly stated, is more so, as your friends have suggested, that we're going to, approach this wave of applications that could occur. And part of the reason why that wave of applications occurs is because we've essentially reduced what would have been a more complex analytical framework into a much more simplified one, thus producing, what we see in Alberta with the unprecedented spilling over of all of these applications that then strains judicial resources. So it's sort of like this connected question of, if we're oversimplifying things, and if all you really need to do is plead reasonableness or procedural fairness, well, now all of a sudden your application gets brought in front of a judge, and now thousands of dollars of Canadian taxpayer money is spent on potentially unmeritorious applications.
I'll answer your question in two parts, Justice. The first is, we understand that post-Kella there was, as demonstrated in Latham, a floodgates of claims. However, the court was able to deal with that floodgates of claims by establishing an accelerated route to access to habeas. So it's not to say, to use the bench's words as well, it's not to say that the courts were broken. The courts were able to alleviate those concerns of floodgates. And in addition, Justice, if it is our friends' position that it is on a risk of a floodgates being opened, that as a matter of a threshold issue, access to the writ should not be allowed at all, we would say that that does not comport with May, where May demonstrated that access to habeas corpus cannot be limited due to issues of mere convenience.
Aside from the procedural differences, is there any daylight between the habeas corpus doctrine that you're describing and a judicial review? Because it sounds to me that what you're describing is just a judicial review, but faster.
Especially with the language of unreasonableness and procedural fairness. You owe the same amount of deference to the decision maker. Do they not?
Certainly, Justice. And our friends advance the claim that our view is not giving deference to administrative decision makers, which I will touch on, but Justice, primarily to your question, there is a meaningful difference between not only what the applicant has to demonstrate in terms of unlawfulness for judicial review, but also Well, that difference is laid out in Section 28 of the CCRA. Section 28 of the CCRA lays out, A, multiple grounds of unlawfulness that don't require the standard of being charter cognizable, but in addition, many other remedies that the court can issue when dealing with an application for judicial review. The issue that habeas corpus is responsive to is A, issues of reasonableness, procedural fairness, and a lack of jurisdiction, and the only remedy, that remedy is non-discretionary. That remedy is release. And that remedy is release for a meaningful reason. There is active restrictions on liberty, and an applicant should be entitled to access habeas to remedy that situation.
What do you mean by the word release? Are you suggesting that misclassification mandates the release of inmates, or are you expanding the use of the word release to also mean correcting the misclassification?
We mean correcting the misclassification. We don't mean that an inmate who's in maximum security will then be released into the general population. We say that, and comporting with this court's jurisprudence, Kella, May, even Chinna, even in an immigration context, the remedy that was sought was release from the particular constraints on liberty that an individual inmate was facing. And of course, that doesn't mean release into the general population. We say that wouldn't strike a meaningful balance.
So, Counsel, one very important distinction that I see between a habeas application and Section 28 that you cited here is that habeas is very much of an individual-focused remedy. Section 28, although it talks about a least restrictive environment, still looks at other factors such as the safety of the public, the safety of that person and other persons in the penitentiary, the security of the penitentiary, as well as other factors that are listed there in the statute, meaning that it's invariably going to be a better decision. So why not make those decisions under that framework?
At the outset, Justices, I see my time may very well elapse by the time I answer your question. May I request an indulgence of 1 minute, an additional minute to...
Please proceed to answer the question and then you can wrap up.
Certainly, Justice. So I have two answers to your question, Justice. The first is that habeas corpus still deals with issues of unlawfulness where the state can justify that not providing access to habeas is warranted. For example, if an applicant is not transferred to a lower security penitentiary because of a lockdown in a prison, that would be the state can bring up that factor when the burden shifts to the state under that third step of access to habeas. So it wouldn't mean that in all circumstances in a case of unlawfulness, the remedy is always release. And Kella also deals with this question. There was a breach of procedural fairness, which ordinarily should mean release, but there was no release. And secondly, Justice, to your claim or your point, which we do take that perhaps it is inherently better that federal courts do deal with these issues. We say that May has already set out concurrent jurisdiction, and May also enunciates that there should be a choice in venue. That's no reason to limit access to habeas. Barring any further questions from the bench?
No, thank you, Counsel.
I'll turn it over to my co-counsel. Thank you. May I proceed?
When you're ready, Counsel.
Good afternoon, Chief Justice, Justices of the Supreme Court of Osgoode Cup. My name is Anasofia Florez, rising before you to finish submissions on behalf of the respondents in this case, Mr. Frank Dorsey and Mr. Ghassan Salah. My colleague has demonstrated that even if this court is to read Dumas as requiring entitlement strictly, Dumas has been attenuated through legal change. We have two remaining submissions for this court. First, in the alternative, if this court is not compelled by the legal change submissions, it's additionally been attenuated by social change. And second, the Attorney General's expressed policy concerns are far outweighed by society's interest for granting access to habeas corpus given the lack of adequate alternatives. To begin, Dumas has been attenuated by a societal change since its release in 1986.
Sorry, Counsel, I'm
Yes,
really
Justice.
stuck on this point raised by your colleague. If unlawfulness can be made, the determination of unlawfulness can be made with reference to unreasonableness as one criterion, how is that not a discretionary analysis?
Justice, may I ask what you mean by discretionary analysis?
You said habeas corpus is non-discretionary, but judicial review is. How is that not just importing judicial review into habeas corpus?
So when my colleague mentioned that habeas corpus is non-discretionary, that is to say that the remedy is automatic. There must be release from the thing that is depriving the inmate of their liberty.
But if it's that the decision is unreasonable, isn't the thing that you're entitled to a reasonable decision? And if the problem is that you had a procedurally unfair decision, isn't the remedy a procedurally fair one? It's not a substantive change in the conditions of confinement, it's a new decision, and that's exactly what judicial review is designed to do. That's why ordinarily decisions are remitted back to the decision maker, and why they are not made by a substitute decision maker, which would be the court.
Well, Justice, it's true that in some cases a fresh decision is ideal. That isn't to say that that contradicts May's holding that multiple avenues should be made available to inmates, including habeas corpus as well. So that doesn't contradict with the respondent's position.
But it doesn't have to be multiple avenues for everything, right? I think the concern is about an overly expansive approach towards habeas.
Well, Justice, we agree that is our friend's concern. This isn't an overly expansive approach. It's an approach that is necessary because where the alternative avenues are inadequate, wholly inadequate.
Inadequate for whom, though?
Inmates, Justice.
Only inmates?
Well, Justice, we're speaking about the internal grievance procedures and then judicial review with respect to reclassification decision denials.
Sorry, Counsel, so when you say they're inadequate, you mean they're inadequate because they're ineffective?
Well, Justice, they're inadequate because they're too slow, because they don't address any of the issues regarding impartiality from previous decisions. To be clear, I'll handle each...
So if they're inadequate and they're slow, are they not therefore ineffective?
Well, Justice, I'd agree with that.
You'd agree with that, so then pursuant to section 50, paragraph 56 of the majority decision, complaints that the inmate grievance procedures are ineffective are barred from habeas corpus, no?
Yes, Justice, but that's not our position. Our position...
You just agreed with me.
I think we might be using the word in different contexts. To be clear, the reason why habeas corpus would be available in our client's case is because there was a reclassification denial which amounts to a deprivation of liberty, and there is basis here, for example, or in any particular case based on the facts of the case for unlawfulness. That portion you just read was that it's not inherently unlawful, just that a grievance procedure is seen to be inadequate. Rather, there has to be particular bases for that. We're talking structural issues.
Is there one correct classification for every inmate?
One correct
Yes.
classification?
It's, my understanding of the entire regime is that it's discretionary. There's a decision that is made. We think such and such inmate ought to be in such and such level of security prison, or whatever. Is there one answer to that question?
No, Justice.
Then what are you asking for under habeas as a remedy? Are you asking for a new decision? And this is what's confusing me. It seems like you want to say it's unlawful because this person should be confined differently. And I'm asking why? Like, what substantively is the problem with the earlier decision?
Right. So, Justice, to be clear, the question in habeas corpus is not whether something is unlawful because a court disagrees with the decision. It's whether it's unlawful, for example, because of procedural fairness, or because it lacks evidentiary basis, or because it's arbitrary. In this case, we would say that there are many examples, or there could reasonably be examples where, despite having no legal entitlement per se, it's still unreasonable and arbitrary. Hence, there must be access to habeas corpus to deal with those types of cases. I'm not...
The premise you just said, and I could be misunderstanding, did you not just say it's a court made a decision and thus going up? The whole idea of habeas corpus in this circumstance is a decision that was not made by a court. It's a decision that relied on an evaluation for one person, evaluation for another person, and then ultimately a decision made, for example, by a warden. That's not a court.
Well, we'd agree with that. The CSC is not a court, Justice. The reason why, nonetheless, that should be given access through habeas corpus is because the Supreme Court, for example, in May at paragraph 63, made clear that the CSC's internal grievance process lacks impartiality, doesn't have any remedies, doesn't give any legally enforceable decisions, and the effect of that has been substantial. Per the John Howard Society's factum submitted to the Supreme Court in paragraph 14, they noted that CSC does its own directive, doesn't even give itself enforceable deadlines. The impact has been noted. It shows. The national headquarters...
So I think we understand the impact on the inmate. That's very well detailed in the Supreme Court of Canada's decision. I guess what I'm grappling with is that is security classification exclusively assigned to an individual, as we heard from the previous question, or is it also informed in the aggregate? In other words, if you have a number of individuals with security classifications, but they're in a different mix, is it possible that that classification then changes or shifts?
Absolutely, Justice. We'd contend that would be able to be raised by the state in the third step of KELA. So I infer that your concern is about whether that could be accounted for through habeas corpus. It would be per the third step.
Well, I understand it can be accounted for. I'm trying to understand how it's better accounted for through habeas.
This is about having access to the various routes. Habeas corpus is both a right and a remedy in this case because there isn't a better alternative procedure, rather than saying habeas corpus is necessarily better.
Well, this is what I'm trying to say. Why is it better? I understand May says you can have multiple routes. Okay, why is it better to do it through habeas as opposed to through the faulty, albeit faulty, grievance system that we have currently?
Yes, Justice. What I was trying to articulate is that the question is whether there are better alternatives, not necessarily whether habeas corpus is better. That's the May standard. But we'd argue habeas corpus is better. It's faster, and it doesn't require that we rely on the CSC's decision.
Well, I think we understand the speed component too. I think the problem is the deprivation of liberty and the legal problem or error here the outcome, or is it simply that the process itself is faulty? I'll put it to you differently. Can you explain to me how any inmate wouldn't want to have a lower security classification?
Surely they would. However, that's not a problem with respect to our position. There is a limiting principle with respect to habeas corpus. It was articulated, for example, in Ewanchik. It was even articulated by this bench to our friends. Aspects of conditions of confinement, such as, for example, food, music being played. It seems this court, our friends and I, and us, we are in agreement about those things being a limiting principle as well.
So I'm not concerned about those. What I'm really concerned about is where you have recommendations made by some staff, who might be frontline staff, but those frontline staff don't have the macro perspective that we just alluded to about the different mix of security elements.
Right. In that circumstance, Justice, the macro perspective would be brought up under the third step of habeas corpus.
But it just seems like a very redundant, another judicial review, albeit in another name, that isn't as perhaps robust. I think that's the concern here.
The reason why it's not redundant, Justice, is because we know that judicial review is inadequate because it doesn't actually challenge the underlying decision relating to reclassification denial. It only challenges or reviews the grievance procedure through the doctrine of exhaustion. Additionally, the only remedy in judicial review is remittance to the CSC itself. And we take issue with this because the CSC itself also has problems with its internal review procedures, as articulated by May, and as has been shown by the wait times they have when it comes to these procedures, 217 to 281 working days. It's unacceptable.
Counsel, I'm going to go back to the question that I asked you, that you agreed with me, and then you changed your position once the actual lead was put to you. You've just said now that the system is inadequate. You've just said that it takes too long. Complaints that the inmate grievance procedures are ineffective is a bar for habeas corpus. And this is the position you present to us. Please explain how you get around a position you agree to, then disagree to, and then use different vernacular such as inadequate in order to explain.
Justice, to be clear to the bench, I'm arguing in fully good faith. I believe we're differently interpreting that sentence. Our understanding of that sentence is that the mere fact that the grievance procedure is found to be inadequate in cases like May doesn't give grounds for unlawfulness under Kella Step 2. That's different than what we're saying. We're saying that Kella Step 2 ought to be able to be evaluated, as in, under Kella Step 1, this is a continuation of a deprivation of liberty.
Why is an order of release pursuant to a habeas application an appropriate remedy for a procedurally unfair or arbitrary decision?
Why is it?
Why is that so you have your remedy, which is release. You have your problem, procedurally unfair or arbitrary decision. And I'm asking, why is a release the appropriate remedy for that problem?
Okay, well, two parts. First, it's the appropriate remedy because in Canada we have a constitutionally granted right to not be unlawfully detained by the state. And then we have the right to be released if it's unlawful. Secondly, Justice, that wasn't raised by our friends at any point during today's proceedings. The question is solely a question of law with respect to whether a continuation of deprivation of liberty can be found where there is no legal entitlement to a lesser depriving condition. With respect to societal change, which I'm not sure I quite got to, unless there are any further questions about the submissions already presented. Okay. So Dumas was decided in 1986. In the time since then, Shubley, for instance, was both decided and then overturned. Decided in 1990, overturned last year in John Howard Society of Saskatchewan. When the court overturned Shubley, what it said explicitly was that it was rejecting the, quote, abstentionist approach it had taken with respect to the carceral institution up until that moment. That is to say, up until that moment, there was a hands-off approach with respect to its carceral institutions, and now there is a hands-on approach, a non-abstentionist approach. The reason for this was perhaps best articulated in 2018 in the case of Ewing. where the court admonished the CSE for its risks assessments, which it found to be discriminatory. Of note is that in 2024, years
Sorry,
after...
counsel, which paragraph do you find that case you in the Supreme Court of Canada decision?
Justice, I don't have that in particular. I know it is cited in it, and if not there, or if you can't find it immediately, it is cited at paragraph 18 of the Aboriginal Legal Services Factum, which is within scope for this moot. Now, on that paragraph, it noted that in 2024, years after the Ewing decision was published, the OCI noted that CSE hadn't taken any steps whatsoever to address what the court had said in Ewing. And perhaps this is why then, in Vavilov, the preceding year, in 2019...
Counsel, I'll just let you know you've reached your 14 minutes.
Oh, Justice. Unless the court would like me to conclude, I'm happy to wrap up for expediency.
I'll ask you to wrap up.
Yes, Justice. In conclusion, Dumas has been attenuated. That is to say that it is up to the court to decide whether or not entitlement is a requirement. We say it shouldn't be because the concerns the Attorney General has brought up are not compelling here. There is a societal interest in including access to habeas corpus in such cases. Barring any further questions.
No, thank you very much,
Thank you
counsel.
for your time, Justices.
Thank you.
The right of reply. Right of reply? No? All right.
All rise. Veuillez vous lever.
So now we get to announcing the winner of the 2026 Osgoode Cup. And without further ado, the winner is Team 78, Neha. And we obviously need to recognize our second place winners.
I'd like to invite Andrew Monkhouse up to the podium now to make final closing remarks for the 22nd annual Osgoode Cup.
Yeah, so it's been an interesting cup, right? So obviously we're trying out some new electronic systems, trying to have some improvements, and you know, we're going to work on things for that. But on the upside, churros, right? Churros, who enjoys the churros? Every year running the Osgoode Cup is different and difficult. When I took part in the Osgoode Cup, I think there were 24 teams. I already mentioned my lack of success of moving on to the second day or getting any sort of oralist award. Even though it was a much, much smaller competition, we're looking at, you know, almost 130 teams this year. And so we've 139. And we've expanded moving on to the second day, but it's still also often very difficult. Every year we try to have a better example of mooting. We have, you know, folks recording it so that way we can put those up. And that's trickled through to things like law school. When I teach mooting in law school, a lot of those people now have been mooting for longer. They've been mooting since high school. There's a whole circuit, I'm given to understand, of other Osgoode Cup copycats. I mean, great organizations that also run undergraduate moots, and we are happy to have them because there's lots of innovations from those moots that we're able to cycle back as well. And so I think that's one of the things that the Osgoode Cup, when I took over, I thought to myself, what were some of the things that I want to do better? And I dedicated myself to that. We had a number of students who had participated in the Osgoode Cup and wanted to come back and had great recommendations this year. And so I think that that's really great. So it falls to all of you and those who aren't here right now as well, though, to, you know, make that your goal. Whatever law school you go to, we, you know, although we like Osgoode a lot and have a lot of Osgoode volunteers, we've had certainly volunteers from other law schools. You don't have to go to law school. You know, someone who, one in my year, went and became a doctor. I don't know. So that's fine. That's like an acceptable option as well. So it's probably also okay for society, I guess, to have more physicians. Anyway, okay. They're more useful on airplanes with this medical emergencies than I am. But that's okay. The point is that, you know, if you want to be part of the Oz Cup in the future, be it a volunteer, be it if you do go to law school and you want to get involved, you will have ideas about how to make things better. We're constantly, you know, 3 steps forward, maybe 1 step back, trying to make things better. And it really needs feedback from all of you. We will be sending out a survey, you know, and so that's something to think about. But really, this whole event, given how many people, we have the logistical difficulty of that, it wouldn't have been possible without the student volunteers. So just ask everyone to give a round of applause for all the student volunteers. Generally the organizing committee, and then people like Jen, who, you know, is the backbone of everything here. And so, you know, thanks for the Jen, Kristina, who are all part of the organizing committee, and not just because I asked them to from Monkhouse Law. Thanks so much for helping out the 3 of you. So there you go. They came in here for their weekend as well. So yeah, just look, it's a great. I just encourage everybody to have their schools send people again next year. We'll be sending out dates, but we expect that there will be a weekend in March when we'll be back here again next year, and you know, working hard at it. So you know, everyone's had a long weekend. I've had a long weekend. I'm starting to ramble on, so we'll call everything to a close. But thanks everyone for all the volunteers and judges and everyone for coming out. And take care, and we'll, you know, call it all adjourned.